Hello students, welcome to AKS IAS. In this video, we will be discussing about the anti-defection law and what are the challenges that this law has faced in its implementation. So what is the basis for us discussing this issue? This article was published on Revolving Door on Manipur Politics, which was published in the Hindu recently. So, in this article, there was explanation about the politics of defection in India and the related challenges in the anti-defection laws. Recently, some of the sitting MLAs of the Manipur government defected to the opposition party, creating instability in the state's polity. The politics of defection in Manipur is not unique. There have been some other recent examples of defection in the states of Karnataka, Madhya Pradesh, as well as Arunachal Pradesh, along with Uttarakhand. For a very long time, Indian political system was impacted by political defections by members of the legislature. This situation brought about greater instability and chaos in the political system. Thus, in the year 1985, to curb the evil of political defections, the 52nd Constitutional Amendment Act on Anti-Defection was passed and the 10th schedule of the Constitution was added to the Indian Constitution so as to prevent horse trading, so as to prevent instability in governance. This anti-defection law was passed and the 10th schedule was added to the Constitution. However, though the law has been passed, the recent examples of defection in Indian polity show that the law needs a relook in order to plug the loopholes and achieve a balance between the rights of legislature, between the rights of the legislators, that are the MLAs and MPs, and the interest of legislative stability. So the author states that there is the issue at disposal is the fulcrum of balance between the rights of the legislatures as individuals as well as the legislators, and the interest of legislative stability, that is to have a stable polity and stable governance. So what are the issues associated with the defection? Number one is the subversion of electoral mandate. What do we mean by this? Defection is a subversion of electoral mandates by legislators who got elected on the ticket of party 1, that is, let us say party X, but then they find it convenient to shift to another due to the lure of ministerial birds or other financial gains. So, in an election, people tend to, the electorate or the voters tend to choose a particular candidate to represent their interests because they repose faith in a particular candidate and a particular political party. However, after the candidate wins in the election, they are getting lured by ministerial birds or financial gains and they're subversing the electoral mandate. Number two, defection affects the normal functioning of the government. In the infamous Ayaram and Gayaram slogan was coined in the background of continuous defections by legislators in the 1960s. That is, the MLAs or MPs were elected on a particular party ticket and then they were defecting to other parties. So this led to a culture of Ayaram Gayaram, that is, a person is coming and going. So this was rampant in the 1960s. So the defection leads to instability in the government. So because of these defections, the ruling party was always getting into a minority and there was instability in the government and there was political chaos. And that affected the overall governance and the administrative system. So that is why in the year 1985, the anti-defection law was passed. Number three, promotes horse trading. Defection promotes horse trading. Defection also promotes this, quid pro quo or horse trading of legislators, which clearly goes against the mandate of a democratic setup. So, Now let us try to understand what is the 91st Constitutional Amendment Act of 2003. This act of 2003 aimed at limiting the size of the Council of Ministers to debar defectors from holding public offices and to strengthen the anti-defection law. So this 91st Constitutional Amendment Act of 2003 was promulgated so as to complement the anti-defection law. Earlier, a defection by one third of the elected members of the political party was considered as a merger. 91st Constitutional Amendment Act changed it to that at least two-thirds of the political party, at least two-thirds of the members of the political party, if they, switch sides or they split from the parent party, then it is legally recognized as a merger. So that made the provision of defection more stringent and difficult. Next, now let us look at the Kihoto Holan case. What is this? This Kihoto Holan case of 1992. In this judgment, the Supreme Court clarified that the 10th schedule of the Constitution is constitutionally valid. It said that it neither impinges upon the freedom of speech and expression nor subverts the democratic rights of the elected members. So, this 10th schedule of the Constitution was challenged by one petitioner stating that it impinges upon the freedom of speech and expression as well as the democratic rights of the legislators. However, in the Kihoto Holan case, the Supreme Court ruled that the 10th schedule of the Constitution is constitutionally valid and has legal as well as constitutional sanctity. Next, in this judgment, it was also upheld that the sweeping discretion available to the Speaker in deciding the cases of disqualification of the MLAs. So, it said that according to the 10th schedule of the Constitution, the Speaker has the discretion in deciding the cases of anti-defection. So it upheld the in the Kihoto Holan case, the Supreme Court upheld that the Speaker definitely has this discretion. However, the court held that the Speaker or the presiding officer's decision of disqualification shall be open to judicial review. So until this Kihoto Holan case, it was thought that the Speaker's discretion was beyond judicial review. However, in the Kihoto Holan case, the Supreme Court held that the Speaker's discretionary powers regarding the disqualification of the legislators is within the purview of judicial review. If at all the Speaker has disqualified a particular legislator with malafide intentions, definitely he can be questioned on grounds of having any malafide intentions, and the Supreme Court can strike down the decision of the Speaker. Next, what are the challenges to anti-defection law? So, in the implementation as well as the spirit of anti-defection law, there have been certain challenges. Let us look into this. So, number one, it is against the true spirit of representative democracy. Some critics argue that the anti-defection law seeks to provide a stable government by ensuring that the legislators do not switch sides. However, this law also enforces a restriction on the legislators from voting in line with their conscience and judgment as well as the interest of his electorate. Okay. Number two, it impedes legislative control on the government. What do you mean by this? The anti-defection law impedes the oversight function of the legislature over the government by ensuring that members vote based on the decisions taken by the party leadership, but not the mandate of the people whom they represent or their individual conscience and what they feel is right in their own judgment. In short, if the legislators are not able to vote on laws independently, they would not act as effective check on the government. Number three, The anti-defection law, in effect, dilutes the separation of powers between the executive and the legislature and thus centralizes the power in the hands of the executive. So, indirectly, it is leading to dilution of separation of powers, and it is vesting utmost power in the hands of the executive. Next is the role of the presiding officer of the house. This has also been a bone of contention and led to many debates on what is the role of the presiding officer, that is the speaker in the case of the legislative assembly and the Lok Sabha, or the chairman or vice chairman in the case of Rajya Sabha. The law lays down that legislators may be disqualified on grounds of defection by the presiding officer of the legislature based on a petition by any other member of the House. This is what the law states. So, what is the issue with this? However, there are many instances when the presiding officers play part with the vested interest of a political party or the government in power. This has been happening or taking place in many instances where the speaker's discretionary powers have been used to the advantage of a particular party in power. Also, the law does not specify the time period for this presiding officer to decide on the disqualification plea. So, in many cases of defection, though there have been complaints to the presiding officer that certain action has to be taken on due to the defection of a particular legislator, many a times the speakers have not taken any decision, and as there is no time period within which the speaker has to take the decision, so in many cases the party in power had, you know reversed or subversed the mandate of the people, mandate of the electorate. So they were taking up MLAs from the opposition party or MPs from the opposition party, and the speaker was not taking any kind of decision on the same. And due to the delay in taking any decision, the elections were also around the corner. So the legislators, whoever have defected, they were in power till the time the next election comes in. So the decision thus is sometimes based on the whims and fancies of the presiding officer or the speaker. Next, it affects the debate and discussion. So the anti-defection law has created a democracy of parties and numbers in India, is what some of the critics state, rather than a democracy of debate and discussion. So what happens is, there could be a particular person in the ruling party. He might not agree on certain policies, or he might have differed opinions on a particular policy that is being taken up by a ruling party or an opposition party. But due to the fear of anti-defection law, that legislator is not able to speak out his mind. Okay, so in this way, it does not make a differentiation between dissent and defection and weaken the parliamentary deliberations or discussions on any law. So now let us discuss what are the possible steps to be taken so as to strengthen the anti-defection law and so as to ensure the smooth functioning or the implementation of the anti-defection law. Number one, rational use of anti-defection law. What do you mean by this? Several experts have suggested that the law should be valid only for those votes that determine the stability of the government. Example, you can quote the example of the passage of the annual budget or the no confidence motions. So, whenever a no confidence motion is moved against the ruling party or the government, so the government, if the no confidence motion is passed, the government has to resign. So some of the experts state that this anti-defection law should come into force only in these kinds of substantial, in this kind of instances where the substantial evidence, where if at all a particular legislator doesn't vote for that bill, there could be instability in the government. Number two, advice of the election commission. Various commissions, including the National Commission to Review the Working of the Constitution, have recommended that Rather than the presiding officer, the decision to disqualify a member should be made by the president in case of the members of the parliament, or the governor in case of the members of the legislative assemblies, on the sound advice of the election commission. Because we see that a lot of times the speakers who belong to the ruling party have acted in a biased manner. So this is one of the recommendations made by the NCRWC. Number three is the independent authority to deal with disqualification. Justice Verma in the Holan, that is the Kihoto Holan case, said that the tenure of the speaker is dependent on the continuous support of the majority in the House. Therefore, he does not satisfy the requirement of such an independent adjudicatory authority. As we were discussing, that there could always be a possibility that the speaker will act in a biased manner in support of the ruling party. So also the choice of the speaker as the sole arbiter in the manner violates an essential attribute of the basic feature of the constitution. Thus, the need for an independent authority to deal with the cases of anti-defection is very much required, is what the Justice Verma had recommended in the Kihoto Holan case. The next point is promoting the principle of intra-party democracy. The 170th Law Commission report underscored the importance of intra-party democracy by arguing that a political party cannot be a dictatorship internally and democratic in functioning outside. So in more than one ways, anti-defection law is impinging upon the democratic functioning of the legislature. Is the argument by some of the critics. So here they say that there should be the promotion of principle of intra-party democracy and inter-party democracy. Thus, the parties should listen to the opinions of the members and have discussions on the same. This could give the freedom of expression and freedom of speech to the members and promote inner party democracy as well. Okay. So how do we conclude? So the author concludes by stating that though due to the anti-defection law, political instability caused by frequent and unholy change of allegiance on the part of legislators of the country have been contained to some extent, yet there is need for a more rationalized version of anti-defection laws which will help establish a truly representative democracy. So that was about anti-defection law, the purpose of the law, and what are the challenges and the prospective suggestions on implementing this anti-defection law. Now let us look into a question regarding anti-defection law. Before that, let us try to understand the difference between a direct democracy versus a representative democracy. So students, you try to answer this question whether India is a direct democracy or an indirect democracy. So what is a direct democracy? A direct democracy is a form of democracy where all the laws and policies are created by a general vote of the society, that on any kind of legislation, all members of the society are going to vote. However, in a representative democracy, where India is a representative democracy or an indirect democracy, is a form of democracy where citizens vote on representatives to create laws and policies on behalf of them. We, the citizens of India, are voting our MPs or MLAs so that they represent our interest, the interest of the electorate in the legislatures. So that is about the basic difference between direct democracy and representative democracy. Number two, there are no intermediaries in the direct democracy. The vote of the citizens directly determine all the laws and policies of the government. However, in a representative democracy, people elect representatives to create and amend laws and policies on their behalf. A direct democracy is more direct and transparent in manner. However, the representative democracy, as compared to direct democracy, is less transparent, because the business of conducting legislations is done in a legislature, that is the Lok Sabha or the Rajya Sabha or the state legislative assemblies. However, the direct democracy may be less efficient, especially when the population of a country is huge. Comparatively, a representative democracy is more efficient. So, what are the examples of direct democracy? You have some elements of direct democracy in Switzerland, and it was also existed in ancient Athens. And what are the examples of indirect democracy? You have the United States of America, India, United Kingdom, and France. So now let us try to look into a question based on anti-defection law. So please try to practice this question and try to answer this question based on the discussion that we had. So the 52nd Constitutional Amendment has curbed the evil of political defection and made Indian polity more stable. Critically analyze whether you agree with this statement or whether you do not agree with this statement. Try to put in your points and try to justify your point of view. Thank you. Have a good day.